This cannot possibly be in the interests of the United Kingdom and the people of the United Kingdom. Now, there's been a lot of heat recently between the judiciary and politicians. Now, I'm not quick, as you well know, to criticise the judiciary, and this video won't be any exception. I'm not going to criticise the judge in this case. What I am going to do is criticise the law that the judge is applying, because if the judge says this is how the law applies and this is the outcome, which I think is ridiculous, by the way, then I can say that I think the law's ridiculous. I am perfectly entitled to say that, and I will tell you why, and you can make up your own mind. You don't have to believe what I think. I am an independent barrister giving you my views on the law, and I am entitled to do that. So for that, if you like these open and brutal opinions, please do subscribe to the channel. I'm independent and I depend on you to do that. So what are we talking about here? Because this really is outrageous. This is about a Syrian asylum seeker who then became a convicted sex offender, and the judge in this case has to decide whether sending him to prison would breach his human rights. That's the headline, and it sounds utterly preposterous, and I think it is utterly preposterous. I can't sugarcoat this and tell you that I think this is a sensible discussion to have. There is an argument behind it, which I will give you. There is a logical argument. Not that I agree with the argument, not that I think you will agree with the argument. And I think if we did a poll, I think well over 90%, in fact, I'll do a poll in a minute, I'll link it in the description below. I think well over 90% of people will say, no, just send him to prison. If he's committed this offence, send him to prison. Or you might say deport him. If he's an asylum seeker and committed an offence here, you might say that he doesn't deserve to be here and doesn't deserve his asylum claim being considered and needs to be deported. That may well be your view. This is not me sowing hate, by the way. This is an open discussion. People may hold those views. They're entitled to hold those views, and despite what some police seem to think, they are entitled to express those views. So long as they are not inciting violence and sowing divide and so on, you are entitled to that view. But let's have a look at this story here. I'm going to choose words carefully, so you'll forgive me. You can read the article yourself. I'll link it in the description below, because YouTube doesn't like certain words. But let's jump, first of all, to the bit that he did wrong. Now, that's not being an asylum seeker. I'm talking about the offence that he committed here. So, vulnerable women, you can draw some inferences from what happened here if I leave a few words out, but vulnerable women. During the early hours of December the 18th, 2022, he drove into town looking for women to target. He spotted his victim at 3:25 a.m. She'd left a nightclub and she'd called her dad to pick her up. Whilst she waited for him, she sat on the pavement alone. CCTV caught this guy, stopped his car, approached her before helping her up from the ground. He assaulted her as described here, and then she shouted for help at 3 people walking by, and her father arrived on the scene as this guy drove off, and then he found his daughter with these 3 strangers, distraught and crying. He then told the police that all of this was a misunderstanding, but ultimately he was found guilty and convicted of this offence. Now, where's the problem in that? So he was convicted of this offence, very serious offence against this poor lady. Now, the argument by the barrister here, now again, I am going to say that I don't want to attack here against the barrister for making this argument, because as advocates, it is our job to put forward any argument, even if that's from someone who's been convicted, to try to keep them out of prison. As an advocate, it is our job to do and to say what we can within the rules, within the law, in the best interests of our client. And that includes a client who's just been convicted of an offence. So no attacking the barrister here, please. The doctor made the following argument. And it's a valid argument to make, not to say that it might lead to the conclusion that the barrister is seeking on behalf of his client, but it's an argument nonetheless. He says, the doctor's report came in on Saturday, and it expressed concerns about his PTSD, post-traumatic stress disorder. He said he has several symptoms of PTSD, which will be made worse by a custodial sentence. It would also be made worse without the support of his wife and his friends. The court must work out whether a custodial sentence would breach Article 3, which is the right against inhumane and degrading treatment. And that is all because he was said to have been suffering from PTSD, having been tortured in a jail in Syria under the Assad regime, who you remember recently was ousted. Now, that is the argument. It's a human rights argument. Now, hence the heat and debate between the judiciary and politicians. Now, judges are applying the law, as it is. And if we don't like the decisions that leads to, we need to change the law. It is not judges that make the law unless they are applying what Parliament has said to a set of facts, and that creates an outcome as to how the law applies in those cases. If Parliament doesn't like it, meaning if we as a civilization don't like it and Parliament wants to change it on behalf of the rest of the country, Parliament needs to change the law. That's how it works. So we have common law, case decisions that are decided upon the statutory and other legislative framework. But if the law's to be changed, Parliament needs to change it. So when it comes to human rights, it is our Human Rights Act that give rise to all of the European Convention on Human Rights, which includes Article 3, which is the right against inhumane and degrading treatment. So this very clever argument here is that because of his very unique experience, which if you take aside from it, this is a mental training exercise that we have to do as lawyers. In your head for a moment, take aside the fact that he's committed this offence and been convicted for this offence. Take in isolation this guy's history of what he's been through and what going to prison would do on his mental health and the treatment of him, etc. Would this go against his human rights, against this sort of treatment? That is the decision for the court to make, aside the fact that he's been convicted of this offence. That is a mental leap to make. But that is why I say that this is preposterous, because whilst it is a very valid argument that this guy has this genuine history, and it is a genuine argument that sending him to prison would bring this back, which I'll come to the judge's comments in a moment, there is then this argument as to whether that breaches his human rights, aside the fact he was convicted of this offence, which, again, I'm not saying I agree with this, but that's the argument. Let's come to what the judge said. So, following the conviction, the judge said, "On the evidence before me, you are potentially a very dangerous man. I shudder to think what might have happened." Because remember, he was sort of stopped in the act, as it were. The judge, after hearing these arguments, said, "A lot of prisoners' mental health gets worse during a custodial sentence." Now, that is true. I'm reading a lot of things about Tommy Robinson at the moment. I don't know enough about it to do a video on that yet, but I am looking at it. A lot of prisoners' mental health gets worse during a custodial sentence, particularly in isolation and all those kind of things. The judge goes on. "However, we are going to take the utmost care and caution due to his PTSD, due to his time and suffering torture in a Syrian prison under the Assad regime. Placing him in prison would provide echoes of that experience." That's a perfectly valid comment to make, so I don't want any attack and criticism of the judge here, much like I don't want attack and criticism of the barrister here making the argument. It's a perfectly sound and valid argument to make, whether you agree with it or not, and it's a perfectly sound and valid comment for the judge to make, whether you agree with that or not. The conclusion that the judge reaches will be whatever the judge says the law applies in this case. And so if the ultimate conclusion is that the law means that we can't send him to prison because it would breach his human rights, and you disagree with that decision, the only conclusion is to change or get rid of the European Convention of Human Rights. And that is a double-edged sword. There's all sorts of rights and freedoms that you have there that you enjoy that you would lose unless they're replaced, alongside those that you think protect chaps like this, who've been convicted of this offence, and now there's a valid argument to say, well, maybe he shouldn't go to prison because of this right not to go through this sort of treatment. Now, the tail end of this, to add insult to injury here, particularly to the victim of this offence, particular insult to this victim here, is that he's now been released on bail. Because, obviously, if he was remanded into custody, then what's the point in going through the process of deciding whether or not this breaches his human rights? Because they're sending him to, essentially, to prison anyway. It's not prison, but it's sort of a holding prison, if you know what I mean. If they're remanded into custody, there's three stages. There's the police stage, the in-between, and then the final prison destination. So one way or another, he would be, if he was remanded into custody, he'd be in some sort of prison anyway. So there's no point making that decision. Therefore, he's been released on a conditional bail. Now, I find that staggering. That, again, I don't invite criticism of the judge or the barrister here. But that is where our law has us right now. The Human Rights Act 1998 has the effect that the European Convention of Human Rights needs to be considered, and the judge will decide whether or not our law is compatible with those rights. That is what the Human Rights Act does. The judge has to make that declaration. And if not, then the judge can either rule that they can't do that because it's in breach of the human rights, or just make a declaration that the law is in conflict with the European Convention of Human Rights. And then it goes back to Parliament, who must do something about it. Now, there's obviously been criticism of this. Chris Philp, Shadow Home Secretary, says it's outrageous that ECHR considerations are potentially preventing a dangerous sexual predator from being jailed. I absolutely agree. I think it's preposterous. So all what I've said, opinion alert, this is an opinion. I try to steer away from opinion, but I have to give you an opinion here. I've told you not to criticise the barrister and the judge. They are looking at the law as it is. So if anything, you criticise the law and blame the law. And then if you don't like the law, you blame Parliament as a whole for not changing the law, but specifically the current government, whichever the current government is, because it's obviously been like this for a long time now, to make changes so that this can't happen. This is yet another loophole that you might see it as a loophole that might need changing. Chris Philp goes on, no consideration seems to have been given to the danger he poses to women and girls and the need to protect them. The legal system should protect innocent people from dangerous attackers and not prioritise the supposed rights of illegal immigrants, who in this case is also a dangerous predator. Sexual predator. With each of these cases, with the Telegraph, which the Telegraph uncovers, the case for fundamental reform on these increasingly absurd human rights laws becomes stronger. And I couldn't agree more. I think it's absolutely preposterous. We have here not only someone that was here illegally and claiming asylum, and that's not a blanket criticism of asylum seekers, you understand. Some are here genuinely, some are not. That's a fact. But also, he's committed a criminal offence here. Now, many people, Rupert Lowe has been very vocal on this subject, many people like that arrive illegally should be deported immediately, and particularly if they've committed a criminal offence here. There is absolutely no logical reason why a convicted criminal in this country who does not yet have permission to be here or refugee status here, there's absolutely no reason they should still be here. They should be deported, or at the very least sent to prison and then deported. But this whole question here is whether or not this human rights element will prevent him even from going to prison. Then doubtless the same argument would be made against deporting him, because he would then presumably make the same argument to say, well, because of what he's done, he faces persecution wherever he came from. Presumably from Syria, because he was in the prison in Syria. Presumably he would make that same argument, that he would face persecution there, therefore shouldn't be deported. And that would probably take a year or 2 or 3 to go through the process, appeals and whatever, which take a year or so at least each. And then potentially the outcome of that is, well, we can't deport him because of the risk to his life if he's deported. So what can we do? That's why at the outset of this video, I said I don't think this can possibly be in the interest of the United Kingdom. So don't shoot the messenger, don't criticise the judge, don't criticise the barrister. These are the laws that they are looking at. The barrister is making a perfectly fine argument, whether you agree with it or not. We see arguments that we don't agree with all the time, otherwise what's the point? We don't always agree with each other. Shock horror, there's always a losing side to a court case. But the judges also have to make these rulings based upon the law. And so the judge is looking at this with all seriousness because the argument's been raised. Now, if the judge just dismissed it out of hand, that would be a perfect opportunity for appeal. Because if the judge dismissed it out of hand and then the barrister appealed, which he would do on behalf of his client to say, judge should have considered it, and that went off to the Court of Appeal, Court of Appeal might then say, well, judge didn't consider it, should have considered it, therefore they step in and step over that decision of the original judge. So that's the problem that we've got here. It's far more nuanced and far more complicated than the headlines make out. No criticism of the headline, but hence the videos. I hope to work in tandem with the newspapers here. Not officially, you understand, just bouncing off their headlines to give you a bit more detail and a bit more viewpoint on these things. Let me know what you think in the comments section below to that one. There's loads more to discuss. There's loads to do with money, Rachel Reeves and this ISIS thing. I'll probably do most of those on my money channel, as I call it, down below, Daniel Shensmith on YouTube, linked below. Go and check that out. And for more of my personal views on these things, I have given you some personal view in this video, I understand, but for my very personal views, check out Black Belt Secrets, link below. And I thank you for watching, and I'll see you next time.